Hello, folks, and welcome to FairCon 2020. My name is Randy Sabett. I am a special counsel at Cooley. I'm in the cyber data and privacy practice in the Washington, D.C. office. In a former life, I was a crypto engineer at the NSA. And I won't say my entire job these days, but much of it is involving the questions that we're going to talk about today around cyber and materiality. And I think one of the most interesting things about this is the way that those technical issues that I used to deal with now play into many of the regulatory and other issues that companies are dealing with today. We have today really thrilled to have a Q&A with Kristy Littman, who is the chief of the Cyber Unit Division of Enforcement at the U.S. Securities and Exchanges Commission. And we're going to go through a quick Q&A, but first, Kristy, if you would, introduce yourself and let us know what you do.
Sure, thanks, Randy. As Randy mentioned, I'm Kristy Littman. I'm the chief of the Cyber Unit, which is situated in the Enforcement Division at the Securities and Exchange Commission. As with all government employees, I have to start my remarks with a disclaimer that the views I express are my own and do not necessarily reflect the views of the Commission or of my colleagues on the staff of the Commission. And then I can stop with the robotic speak. I'll tell you a little bit about the Cyber Unit itself. In the Enforcement Division, we have a handful of specialized units, and the Cyber Unit, as you might imagine, is the newest of the specialized units in the division. It was created almost 3 years ago. And largely our cases have responded to the ICO boom. So we've brought a lot of ICO cases and cases relating to digital assets, some touch on touting of digital assets, unregistered exchanges, unregistered broker-dealers, so kind of digital asset adjacent conduct. But another part of our mandate is cybersecurity. And in particular, there are kind of two buckets to the cybersecurity mandate. One is controls at regulated entities. So when I talk about that, I'm talking about investment advisors and broker-dealers and whether they have the appropriate policies and procedures in place to protect their customer and client data, to protect against identity theft, and to keep PII from walking out the door. And then the other piece of cybersecurity is issuer reporting. And so that's focused on public issuers who have cybersecurity disclosures, either do or don't have cybersecurity disclosures in place, and whether those are sufficient under the requirements of the federal securities laws. And then the third bucket that is kind of in the Cyber Unit's mandate is trading. And that type of work focuses on a variety of different trading conduct, hacking for material non-public information, account intrusions or takeovers, manipulation via electronic platforms. So that may happen by statements made on Twitter or on Edgar. And then there's typically manipulative trading on the other side of those statements. So that's kind of the trading bucket, and that's generally what the Cyber Unit focuses on.
Well, very good. Thank you. Picking up on something you said there in terms of companies, disclosing or not, how do you see companies complying with the guidance or not? And, why, in your opinion, should they take the guidance seriously?
Well, we see, I think the short answer is we do see companies complying with the guidance, and we see, a lot of companies doing a good job with their disclosures. I think there are always going to be issuers who opt not to follow the guidance and opt, or may in some circumstances fail to disclose material events. Or I think, maybe, I don't know if it's more problematic, or if it's more prevalent, but I think one thing that folks need to probably remember is that, you'll make a certain determination about whether a cybersecurity incident is disclosable, right? Whether it's a material event that you need to disclose. But that's not really the end of the inquiry. We do see instances where issuers have made cyber incident disclosures, and they need to continue to think about the sufficiency of that disclosure. So whether it's been whether it's completely accurate, whether it's fulsome, whether it omits any material information. So just the determination that you have a disclosable event is not the end of the inquiry. You also really need to put a lot of thought and consideration into the content of that disclosure. And then the final point I'll make about disclosures is that, we aren't looking to second guess good faith judgments. We understand that when an issuer's been the subject of some sort of cyber incident, they're often the victim. And so they're working to get their arms around a breach in a lot of cases and to remediate it. And sometimes they're working with law enforcement. So we're really not looking to come in and drop the hammer just because your company's been the victim of a breach. We're looking for good faith judgments on these disclosures.
Okay, good. I think that point you made about the company being the victim is sometimes overlooked. And I think, at least in my experience with the companies I deal with, one of the concerns is that, by disclosing, even though they are the victim, by disclosing, they will get looked at, essentially, like you said, as the wrongdoer. I think another area that you brought up, where there's some amount of perhaps a view or a lack of a consistent view is around materiality. So we're dealing with the FAIR community here that was founded with the intent of measuring cyber risk in financial terms and quantifying it. And you've essentially got an audience that was prepared to meet the call that the SEC put forth with the guidance and disclose frequency, impact, et cetera, of cybersecurity events to the board, and then ultimately to the shareholders. But I think there's still a number of different questions around materiality, and you use that phrase in your last response. But when it comes down to it, what constitutes a material event? What's the notion of it? What makes the cut?
So I think, starting just with the kind of basic definition of what it means for information to be material, and there's a lot of legalese built into it, but I think the case law says it, a fact is material if there is a substantial likelihood that a reasonable shareholder would consider it important in making an investment decision, or if it would have been viewed by the reasonable investor as having significantly altered the total mix of information made available to the shareholder. So, that's kind of like the legal, that's where we start from. But that's a mouthful, and it's a lot to consider. So I think what you need to do is look at, how that type of metric or how that type of standard applies to your disclosure determination around the event that you're experiencing. So there are a number of factors that you should weigh, and, like all things disclosure, this isn't a one-size-fits-all, and it's really going to be very facts and circumstances determination, both with regard to, the company or the industry that you're dealing with, but also with regard to the particular incident you're dealing with. And so I think the first kind of bucket of considerations I would say a company should look at is the nature, extent, and the potential magnitude of the incident, particularly as it relates to the importance of any compromised information. So,
and you're talking, just on that specific point, you're talking, I shouldn't say it as a yes, no. Are you talking in the context of just that company, or are you talking about an industry, or are you talking about something even broader when they're making that assessment?
Well, if we're talking about an event, I'm really talking about the compromised information in that event. So, if it's a breach and, account data for some sector of your customers has been exfiltrated, it's the importance of that data to your company.
Your company, okay, good.
And maybe to your industry. that may be a factor, but, those are probably going to be similar considerations. And then I think then the other piece of the nature and extent of the incident is how it's going to impact your company's operations. So, you think about kind of what happens the moment you learn of that breach. Are you shutting systems down that are essential? Or is there some sort of interruption to the company's operations now or future that you need to consider when you're talking about the potential magnitude of the incident? And then I think you need to think about the range of harm that the issuer could experience from the incident. So that harm could be reputational. It could impact your financial performance, particularly if it's going to impact customer or vendor relationships. It could also impact your financial performance if there is litigation that's going to stem from the incident, or if there are regulatory consequences. These are all kind of considerations about the future impact. And, you don't always know at the moment that it happens what those are, but you need to be thinking about the potential for that range of harm when you're considering whether or not this is a material disclosable event. What we don't expect is an issuer to go out and give specific technical information about, the system or the network or the devices that were breached. We don't necessarily want you to highlight potential system vulnerabilities that make them more susceptible to attack. We don't want you creating a roadmap for threat actors. And so we recognize that these are things that disclosure professionals are considering and grappling with when they're responding to a cyber incident. And so, I think our lens is calibrated to those considerations.
Okay. So calibration, measuring, you've talked a lot about quantitative things. And I think one of the questions that many of the members of FAIR and many of the folks involved in the activities, particularly the CISOs, is when the suggestion comes up or when the issue comes up that the company has to do a disclosure, and that there may be an ability to disclose things in financial firms. Some of them might be told by their general counsel that they shouldn't disclose it. And, there might be some issue that could come up that would not otherwise come up if they didn't disclose it in financial terms. They're kind of making the argument that, rightly or wrongly, if they're ignorant on cyber risk, that might in some ways protect the company by, if they didn't do some sort of activity that would reveal something, that's okay. I have a slide I do in another presentation with clients where I have an ostrich, the idea being stick your head in the sand and don't pay attention to it. I think it kind of gives away where my view is on it, but would like to hear what your thoughts are on that sort of advice.
Well, I'm glad to hear that. It sounds like our views might be relatively aligned here. I think what comes to my mind when you give that description is willful blindness. And so from a litigation perspective, that's something that you're always thinking about. And I would say it's never a good strategy from a legal perspective. I think for one thing that issuers need to remember is that in addition to the requirements around disclosing material events, issuers are also responsible for maintaining effective disclosure controls and procedures. And so management needs to evaluate the effectiveness of those disclosure controls. And so you want those controls to enable the company to identify cybersecurity risks and incidents and to think about the significance of the impact on the business. And so, you do want to have, I think it's pretty important from a governance perspective to have open communication between, the technology folks who can make those risk assessments and the disclosure folks who have to make those determinations. And without that kind of open line of communication, I think it's going to be difficult to meet your obligation to make timely disclosures, not just about incidents, but also about the risks that the company faces.
And in terms of, it's funny that you describe it that way. One of the challenges I think that you sometimes run into within the company is sort of the mismatch or the language issue, the language that the business folks and the board use is different than the language than the CISO and the technical community or the technical team uses. When we do talk about materiality, is that what we were just talking about in terms of measuring things, is that a way of perhaps getting across that gap, that communications gap?
Well, I mean, materiality is certainly a piece of it, but I think you also, I think depending on the industry that you're talking about at the company, your governance structure needs to account for the risks that your company faces. So you should have a board, you probably don't need to have a board composed of all cybersecurity experts.
Okay.
But if cybersecurity is important to your company and to your industry and is relevant to your investors, you probably need to have some representation on your board of folks who can, speak that language and understand the risks and help oversee management and their management and disclosure of those risks. So it's certainly not the case that every board member needs to understand all the jargon, but to the extent that cybersecurity is relevant to your company, somebody on the board should.
Okay, good. All right, I'm going to, we've talked sort of in sort of terms that are general. Let's talk here for a minute about something a little more specific. And there we go, I hope. Okay, so here we have some language from a 10K that talks to some of the things that we've been discussing. I don't know that we need to read through the whole thing, but looking at this kind of language, what are your thoughts?
So I guess first let me caveat my thoughts and my reaction by noting that, I'm reading this in a vacuum. I don't have insight into the company or the industry or the particular circumstances surrounding this disclosure, but it looks to me to be a pretty standard disclosure for a company that is not experiencing any cyber incidents. One thing I would note is that you see the word could sprinkled throughout this disclosure. And so that's something I think you do see frequently in risk factors, the words could or may or might. And those are the type of words that I would expect to see in a risk disclosure that's talking about a hypothetical scenario, not an actual incident. And what I mean by that is if you know that you have a breach that is covered, a cybersecurity incident or a breach that's covered by this disclosure, and you're talking about it as though it is a hypothetical that your company could experience such a breach when you know that they have, this isn't going to work. If you have a particular incident to disclose, continuing to say could or may or might is going to be problematic. And that's one thing that I think it's important for issuers to remember when they are dealing with an incident, is that you need to also be considering and thinking about your prior statements and whether any of those need to be revised or updated. And I think even as you move through an incident response, you want to continually think about that. You might come out at the beginning of at the beginning of an incident and make a disclosure, and then you continue your investigation and learn new information and new details. And you should always be thinking about whether your prior disclosures about the incident now need to be updated or corrected. You should also be thinking about the disclosures you've made in your periodic filings. We've brought two significant cases in this area that come to mind when I see a disclosure like this. Those are the Yahoo and Facebook cases. And I should also caveat neither of the Yahoo case, I think this incident started before the creation of the cyber unit, but the case was related to a cybersecurity disclosure. They had a data breach and hackers stole personal data relating to more than 500 million of the company's user accounts. And internally, they referred to them as the crown jewels. Yet for 2 years, their disclosures continued to say, and I don't have them right in front of me, but something along the lines of, we may be subject to this risk, or we might be subject to the risk of a data breach, when in fact they had been, and they were talking internally about the data as the crown jewels. And so, when you've got a very clear incident like that, you shouldn't be talking about it as though it's a hypothetical in your periodic disclosures. And Facebook was relatively similar, although not a cybersecurity breach. That was a misuse of data, but it was the same type of language you saw. You saw may being used in their disclosures, when in fact, for several years, 2 years, I think in that case, they knew that they had user data that was being misused. And so, my kind of initial reaction when I see this is just make sure that this actually is representative of a risk factor and not an actual incident that you're dealing with. And then the other thing I would say is, I don't think that any kind of one-size-fits-all disclosure is appropriate. Any time you're calibrating your risk disclosures, you should be thinking about your particular company, your particular industry, the type of data you take in, the type of systems you have to deal with that data. And so they really should, there's not a standard one-size-fits-all disclosure that's appropriate here. It really should be calibrated to the facts and circumstances of your business.
And I think that's kind of how you started your response, with the fact that, there is no one size fits all, and then wrapping up with that, sort of reinforcing it. I also think that the hypothetical versus the reality is an important one. I guess in that regard, the situations that you've mentioned, and it's the situations that you've mentioned in terms of actions that you've brought, and in terms of the disclosure that you would make over an actual incident is obviously, because it has actually happened, it's easier to disclose, and it's also easier for you and your team to analyze and potentially take action. What about companies that, because again, as you've said, you're not just focused on breaches. What about companies that may not have the best possible cybersecurity posture? Is there a potential that you could go after companies like that as well?
So I guess, what you're really saying is absent a breach, right?
Yes.
So, I would say we've historically thus far only brought actions where we have really kind of egregious circumstances where there was an incident and it wasn't disclosed. But I think, again, you have to look at it through the lens of materiality and disclosure. So I could envision the circumstance in which an issuer has some deficiency or vulnerability that hasn't necessarily been exploited, but becomes public for some reason, right? So they haven't necessarily experienced a breach, but some vulnerability that they have becomes public, and they make a statement about it. And it may be a material vulnerability depending on the company's business and the nature of the vulnerability. And so then it might, you might look at their risk disclosures and say, have their historical risk disclosures been accurate about this risk? But you also will look at the public statements that they make surrounding the issue. So if it's become public and they come out and they, start doing damage control and they make statements that are not fulsome, are not accurate, that overstate their response, then you may have a problem. So if you're going to go out and talk about it, kind of separate from the determination about whether it's a material event that requires disclosure, once you go out and start talking about this vulnerability, you need to make sure that you're being accurate and fulsome and that you're not omitting material information. Okay, good.
All right, I'm going to move ahead to another slide that we have here, and from a Fair Institute perspective, and particularly from a member's perspective, I think there's sort of another question that folks have, or they might be looking for not necessarily recommendations, but thoughts on assessing and mitigating cyber risk. And when a good portion of my job outside of doing things specifically related to either M&A or IPO or any other types of activities like that, when it's just counseling companies, a lot of it focuses on cyber risk. How do we quantify it? What do we do about it? And this is sort of a graph that was put together that kind of lays out a hypothetical, 10 different risks with differing levels of potential impact on the company. And you've got a sort of an arbitrary tolerance dotted line and then an arbitrary material dotted line. And I think the idea here, different people can interpret this in different ways, but the way I look at it, and in listening to the companies that I talk to, you may have situations like toward the right-hand side, risks 7 through 10, and let's, for the sake of this discussion, let's say these are all cyber risks. And the potential impact is below your tolerance, below the company's tolerance, I should say. And in terms of mitigating those risks, I think there might be an argument to say, regardless of what it costs, if it's below our level of tolerance from a damage perspective or an impact perspective, we aren't necessarily going to prioritize those very high. If we go to the other end, like risks 1 and 2, where the impact could be pretty significant, and in fact, in this company's arbitrary way of looking at it, those are material. Not only might they need to put controls in place, but if something were to happen, breach-wise or otherwise, just from an incident perspective, it would be, under your guidance, something they would need to disclose. I think the interesting ones are in the middle, 3 through 6, where it may be above our level of tolerance, but it may be below, materiality. And again, that's subject to debate. But I think when I'm talking with clients, which include both the GCs and the CISOs, often I'm the go-between that's trying to translate. When we're talking about putting in place cyber controls, having a way of addressing them that is quantified is very helpful. So I guess with that as the backdrop, and that's again just my view on this based on what I deal with, I'd be interested in hearing what you have to say to the members of the FAIR Institute, again, about assessing and mitigating cyber risks.
Thank you. So this, my view of this slide is it looks like it's probably represents kind of the internal thinking of the people who have to make these decisions at a company about what goes into kind of the controls that they're going to put in place and what goes into the disclosures that they're making. And I guess the disclosure piece is what I would focus on. One, in addition to disclosing risk factors and disclosing incidents, investors are also entitled to understand and have disclosure around the governance and oversight structure at a company. So a company needs to describe how the board administers its oversight function. And this kind of chart, I think, probably is the nuts and bolts of how that oversight structure works. And so, you need to think about whether you've been forthright with your investors about how you are looking at this and thinking about this, and that's going to vary from company to company, particularly depending on your industry. The other kind of interesting factor that strikes me when you're looking at a chart like this is that it really does contemplate materiality as a strictly quantitative metric. And I think that there are probably some qualitative components to materiality that it's not necessarily possible to include on a chart like this, right? And you really do need to factor those into your disclosure determinations and your control determinations too. So to the extent that the bars in this chart here represent an anticipated cost for remediating, right? So say risk 8 is that bar represents how much you think it's going to cost to remediate an attack on a particular technology system at your company, and you may be exactly right about how much that's going to cost. What I think you can't capture in a bar chart like this is other harm that could flow from a breach or an attack on that system. Is there going to be reputational damage? Could you lose customers or vendors? And sometimes I think trying to game that out in a chart like this is difficult. And so, and perhaps this is already factored into this chart, it's hard to know, but you know, with each of these risks, you know, risk 1 through 10 that you see on here, I think people should be thinking not only about the kind of bottom line quantitative cost of remediating an attack on that relates to that risk, but also all of the different harms that could flow from it, and, you know, where you think that falls on this chart when you take into account all of those harms. You may have, you know, these risks may not be particularly susceptible to reputational harm, and so perhaps it's exactly right, but it's just something you should be thinking about, and make sure that you're taking a step back and taking a qualitative approach in addition to a quantitative approach when you consider materiality.
Excellent. I think that's excellent advice. The half hour has gone by very quickly. I'm sure we could go on for another half hour or more talking about this, but we do need to wrap up. I guess in terms of wrapping up, any final thoughts for the folks and the members at the FAIR Institute at FairCon 2020?
Yeah, I mean, I think I would just encourage, you know, we've talked a lot about the approach that you should take to making affirmative disclosures around incidents and risks, but you should always be considering whether you need to revisit or refresh prior disclosures. And I think, you know, you do see in a lot of our cases instances where, you know, someone you discover a breach or you discover an incident, and you continue to use the same language to describe the risk that it presents, when in reality, you know that your hypothetical has become a reality. And so, and that's true when you're responding to an incident as well. Even as you respond, make sure that you're always just kind of considering whether you have prior statements that need to be updated or refreshed, and make sure that you're really giving your disclosures a fresh look as you learn more about your cybersecurity posture and any incidents that you've experienced.
Very good. Well, I've certainly learned a lot during the session, so thanks very much to Kristy Littman, and I think that's it. Thank you, folks.
Thank you.